Good morning, everybody, and welcome to this edition of MacroPro and Friends, our 12 CEUs of Christmas. I'm Diane Cohen with MacroPro. I'm joined today by Dan Mora from Gemini, Stephen Schneider with Docu-cents, and Mike Callan with Republic. These gentlemen are here representing the Applicant Copy Services. They're going to tell you everything that you need to know or want to know about Applicant Copy Services. I think it's really great that we have this format and we have an open discussion. In the past, I can say that we understand, and there was an antagonistic view, but I think now that's all gone with the fee schedule and people working cooperatively. Would you agree, gentlemen?
Definitely. 100%.
Very, very good. Well, I hope that you gentlemen if you have any questions, I will be glad to ask them of them. So make sure you put those questions in the bottom. So if we could go to the next slide, Stephen, I'm going to do a little bit of housekeeping and let you guys get started because I know people are very, very interested in what you have to say. And good morning, Emily. Emily, sending you guys a good morning. All right, so the 12 CEUs of Christmas information you need to know is that you're going to be getting your certificate like Santa Fast. Within an hour after this broadcast, you will be receiving your certificate. You must be logged on to GoToWebinar. If you're on the phone, you will not be receiving credit because it cannot take time and attendance. If you have an issue downloading it, please make sure you reach out to your IT department first because it's likely a firewall. However, if it is not that, I can assist you for the first 30 days, so make sure to reach out to me quickly. And then if you have questions for our experts, please make sure that you write them down in the chat line, and I will be happy to read those to the gentlemen so they can answer that. And then lastly, we have an encore performance of this on the MacroPro YouTube page, so if you have to want to relive this moment, you can do that there. All right, gentlemen, have a great, great webinar. Thank you very much for coming and speaking to our audience today.
Awesome. Thank you, Diane. Super great to have this invite and great to have Diane in our coalition. And first thing we want to do is kind of describe who we are and what we do. If you didn't know, there's a business and professions code that outlines what we do. And the reason that we called ourselves the Coalition of Professional Photocopiers is because of this business and professions code. So what this does is outline what we do. We make money, or we're compensated to make reproduction of copies of documents. I think there's a question on whether photocopy is still a valid word, and I would challenge that. We're still making copies, and are they photocopies? Well, technically they're image copies or photocopies, doesn't matter. They haven't changed the business and professions code yet, so maybe when they do, we'll change our name. We do take our job very serious, and so you can see in that code section 22458, we are responsible at all times for maintaining the integrity and confidentiality of information obtained. Next slide. So just a little bit of background. Evidence is how the legal world revolves, really. It's the party's right, and it's due process right, legal due process right, and it's supported literally from Magna Carta, which was a document that gave us the English Anglo law, which is what the American law is based upon. And this cascade and these layers of statutes and rules really enforce that due process right. Next slide. Just a little bit more about discovering what it is, and you can read this on your own. But I encourage you to even look this up, the Federal Rules of Civil Procedure and what discovery is intended to accomplish. We believe this is important to us, and we uphold this in our group. Next slide. So this is our mission, or a draft mission that we've put forth to protect and advance the long-term viability of the legal evidence procurement process. We have these sustaining objectives: a unified message, trusted source, industry outreach, improved rules, improved collections. And then on the right there is lists of our member companies. You can see there's a mix of quote unquote applicant leaning and defense leaning services, as Diane mentioned, with the fee schedule and with how things have progressed over the last decade or so. There's a lot less concern and dispute, but there is still some, and we're going to talk about that a little bit.
Okay, my name is Steven, and I want to welcome everybody. I'm actually not a applicant copy service provider, but I was a little over 10 years ago before I sold my company. I'm now with, I formed a company called Docu-cents, and you guys are probably getting lots of mail from Docu-cents. It's a mailing provider. We're trying to sort of drag the world out of paper mail and into, much more efficient electronic mail. But I've stayed involved in this industry the whole time. In fact, the three of us have been talking with the DWC and various entities in the industry since about 2009, 2010, and we continue to do that. We were deeply involved in the first fee schedule and the last fee schedule update that we got not long ago. So we're pretty familiar with how the system works. And that's kind of what this slide is all about, is our view, and what we would hope that is the view for pretty much everybody, is, obviously in this day and age, everything's about opinions, right? So you hear stuff in the news, and you even see studies done, and then you find out, well, that really wasn't based on fact. Everybody's sort of vying for your attention and trying to tell you, what the law says and what you should do about it. The problem with that is it creates a lot of dispute, and we think dispute costs money. It obviously costs copy services money, but it also costs claims examiners, costs the insurance companies and the employers money. And so our coalition is all about trying to reduce friction. And the DWC, the WCAB, they give us the laws, the regulations. The WCAB has given us binding opinions. An en banc opinion is a binding opinion. And so today, what we're going to talk about is kind of some of the core issues that in the past has caused dispute and friction in the industry. And we're going to go over where you can find the actual facts. You don't have to listen. You don't have to agree with us on our opinion of how things should be, but you also shouldn't necessarily listen to your defense attorney or your bill review people, because really they're providers just like the copy services buying for your checks. They want to make money. So the copy service provides a service to the applicant attorney and presents you with an invoice. And what you do with that is up to you as a claims examiner, but you also have now yet more providers vying for your check. Defense attorneys, bill review companies saying, hey, you should object. You should object to that subpoena. You should object to that invoice. That's what we're going to go over today. Should you really object? Something that we kind of stumbled on in a WC IRB report. Actually, MacroPro did. Patty from MacroPro is the one that sent me this, and it's the WCIRB studied, the total medical expenses in the system, and they identified what percentage of that is represented by copy services, and it's less than 1%. It's 0.6% of all medical expenses in the system is what we're talking about here. So throughout the presentation, we're going to keep reminding you of in these areas of dispute, is it really worth it? Because disputes cost money. They cost you money. They cost everybody money. They cost the system money. The judges and the DWC, they don't want copy service disputes being heard when they should be really resolving cases for injured workers.
So hello, I'm Mike from Republic. I'm a small copy service out of Northern California. Diane, thanks for having us here once again, and we appreciate all of your time today. So, as a applicant photocopy service, well, part of our goal here is to present to you, like Stephen was saying, facts versus opinions. And one of the things that we as applicant photocopy services come across is we feel a lot of resentment. We feel that pressure, that dispute, and it comes across, in the mail to us as objections. And so we just wanted to paint those out or show those to you guys so you could take a look at them. There may be more to this, but we tried to narrow it down to a list of about 5 or so. But the first one here is that claims examiners often have records, medical records in your file. And so the applicant attorney hiring an applicant photocopy service is duplicative in your view, and because it's done at your guys' expense. The next area of resentment or objections that we hear is that you guys resent applicant copy services from obtaining records that could be done informally or at a lesser cost by voluntarily providing the employment records or your guys' claims file to the applicant attorney instead of them subpoenaing the records through an applicant photocopy service. The next resentment that we see is that you see applicant attorneys going after all records under the sun from the date of birth to present, and that may seem irrelevant to you other than for apportionment issues. The next source of resentment is that you tend to have contracts with your defense copy services, and why shouldn't an applicant attorney use those services? It's cheaper, it doesn't drive costs, and you already have the contract, and you may also have a copy of the records already, so why not just get it at a cheaper rate? And then finally, there's a sense of resentment that applicant photocopy services are driving the ordering process, and that we are ordering more records than what the applicant actually needs or wants. So we're going to address these today.
Yeah, so we're going to dive a little deeper into the real cost of disputes. Regulation 9981E, 25% increase for all invoices left unpaid for more than 30 days, regardless of objection. Second, Labor Code 4622 increases invoices by 10% and 7% interest per annum. And third, Reg 10786 allows for sanctions and attorney fees to copy services if you failed to object timely, answer objections, and file OR timely with the petition. This is a $500 minimum. So what I want to expound upon a little bit is if you add this up, this could be an additional 42% of cost on top of a copy service invoice. And are you aware of these costs? I think that it's possible that many in the room are maybe new to the industry and maybe just aren't aware of these costs. So part of what we're trying to do is educate here. And as Stephen mentioned, our biggest goal here is when does it make sense to object, to dispute? And also think about who benefits from this dispute, also as Stephen pointed out. Next slide.
Well, I wanted to sort of follow up with, I really want people to connect with this slide because it's kind of critical. Well, it is critical. There are attorneys that are working with copy services that are routinely getting $2,500 awards in sanctions, attorney fees, penalties, and interest. And while you guys may not have run into any of that, you know, we see it because on this side, it's sort of like, hey, wow, you know, look at this. And so more and more copy services are looking to hire attorneys like this because obviously it's lucrative. And so, you know, what we're seeing from our end is, geez, we took a $220 invoice and turned it into $2,500 plus wasted all that board time. That's a problem. That's a problem for employers. It's a problem. It's even a problem for the copy service because you know, the attorney is going to make a lot of that money. It's just layering on more cost. So again, today what we're going to talk about is it really worth it to dispute invoices?
Yeah, and this is just a reminder again that we put up before. 0.6% of medical expenses represent the copy services.
So diving in, duplicative. Are services duplicative? Serve-in records versus reports. When an applicant photocopy service subpoenas records, are those duplicative? Are they? According to Regulation 10635, all parties are required to serve medical reports, not records. Now, report can be, 2 to 5 pages. The medical records, though, are the entire file. So when the applicant attorney is subpoenaing those records, they want more than just the report. They're looking for something that may be included. It could be written on the folder that the doctor is making a note, and they're looking for that evidence. That's why they use us. That's why they're subpoenaing the records.
And I just want to sort of chime in on this. I mean, since I can remember, I got started in this business in 1982, by the way. As far back as I can remember, it's been a standard objection that says, we've served, the copy service will send an invoice for records. And the response will be an objection that says, we served all reports, so your services are unnecessary. And the key to this slide is, of course, you served reports. You have to serve reports. It's your responsibility under this regulation. But the report that a doctor wrote is not the records that the doctor had in his file. And for an applicant attorney, they're going to want to see the background on that report to see if it came to the right conclusions, if it missed anything, and so forth. So, if you're sitting there thinking, hey, I served all the reports, why am I getting an invoice for records? We just want you to realize that reports aren't records. So another thing that we hear about all the time, duplicative records, obviously, that's a big one. So maybe the claims examiner hires MacroPro, and MacroPro goes out, early in the claim and copies records of it can be the PTP, it could be some other third-party medical provider, but they go out and they get records. And at some point later, the application gets filed, and then the applicant attorney issues a request for records from Gemini. And so you're sitting there, you're the check writer, you already had these records, MacroPro had them, MacroPro served the subpoena on the applicant attorney. Now here you are with an invoice from Gemini for the same records. And knee-jerk reaction, they're duplicative. Well, they're not duplicative if they're different pages of records. And furthermore, if we're just going to stick to the codes, regulations, and binding case law, there's nothing that says that the defense going out and copying records and the applicant going out and copying records is outside of the law and shouldn't be paid. There's no, when you look at Labor Code 4622, you look at Regulation 9794, you don't see anything that says records cannot be duplicated. You do see in the Code of Regulations for the fee schedule that records copied by the same party and the same source are duplicative. But that's only if the same records were copied. So if MacroPro went out in January and copied records, and Gemini went out in June and copied records, and Gemini got 25 more pages, they're not the same records. So we want you to be aware of that. It's from the applicant copy standpoint. If the objection is that it's duplicative, that's going to be fought pretty hard. It's going to be, hey, my services weren't duplicative because I didn't copy the same records that maybe MacroPro did. And now, a judge is going to have to review both records and kind of make that decision. And, I'm pretty sure these guys would agree that if MacroPro and Gemini actually did produce the same exact records, and the claims examiner actually served those records on the applicant attorney before Gemini went out and did those copies, then it really is duplicative. It probably really is unnecessary. And Dan's going to say, okay, we don't get paid. He's going to agree to that. But man, 99 times out of 100, there's going to be different images in those records. It's going to be a bit different. And therein lies the root of dispute, and how much does that dispute cost? We really going to turn a $220 invoice into a $2,500 award? I would hope not. So this last part down here, Labor Code 4621, I don't know if you spend much time on that, but that states the reasonableness of and necessity for incurring the expenses shall be determined with respect to the time when the expenses were actually incurred. That's sort of the root behind reason, when people say duplicative, it doesn't say duplicative in 4621. It just says has to be reasonable and necessary. Reasonableness is more a fee thing. Fee schedule pretty much did away with reasonableness as an objection as long as the copy service followed the fee schedule. It's necessity where people will get in your ear and try to create dispute. What is the necessity? But so that's the gold standard. That's kind of what we're working on. So what is necessity? How do we define that? Well, the DWC went to great lengths to give us guidance on when records are necessary. And they wrote it into Regulation 9982. And I'm not going to go through and read all these. You can read these. But each one of these line items are limitations on when an applicant copy service can get involved and should be paid. And so if your bill review company or you or your attorney is making an objection on the necessity of an applicant copy services expenses, we would point you to this 9982. If your objection is not related to 9982, the copy service is probably going to win on necessity, because the DWC has told us as long as the services and invoice complies with this 9982 and all these provisions and limitations, those services should be considered necessary. And I kind of want to follow up with, again, there's a lot of emotion, and I totally get it, because you're the check writer, you're a claims examiner, and you got all these people constantly bugging you, calling you, sending you letters, sending you follow-up invoices, just this huge volume, bombarding you with people trying to get you to write checks. And I would imagine I'd feel, my gut reaction when I get something would probably drive a lot of my actions. I already had these records, I already offered them to the applicant attorney, and now here I got this dumb invoice from an applicant copy service. I get that, but the DWC and the WCAB, they've actually gone to great lengths to give us a highly regulated system from a copy service standpoint, applicant copy service standpoint, and even MacroPro, it's happening to them as well. All these little details, like I just went over in 9982, are ways to create dispute. And we're hoping you'll focus on those details and not your gut reaction. We get it. It's not easy to be a claims adjuster and have everybody coming at you like that. Again, we want to remind you that WCI, less than 1% of all medical expenses. Is this really where you want to spend your time and money? We think probably not. So again, if you're objecting and not paying an invoice, it should be based on regulations 9980 through 9984. That's your key. And if you don't see a problem in those code sections, you should probably pay the invoice.
Yeah, thanks, Stephen. So this is a good question. So are all records from the same witness duplicative? So how would we determine that? It's a good question. So we got in the chat here, we got in the questions from Suzanne Pels. Do you make a good faith effort before you copy the records to confirm that they will not be duplicative of records already obtained? And they need to be clear, like we have no idea whether those records are duplicative until we actually go get them. And even when we go get them, it's pretty unreasonable for us to do that check. And in fact, I think it's a little backwards. If it was me, if it was up to me, if I had a magic wand, if I was king, we would make it so that you would have to prove that they're duplicative or unnecessary after they were paid, is how I would look at it. Images or information obtained were not in the records, were in the attorney's possession and duly served on the applicant prior to the copy service, then the copy services rendered would not be duplicative. So this is another point. Go ahead and keep going with your points there. And then the next point is good too. 9982 states that records previously obtained, and we already talked about this, by subpoena or authorization by the same party and served from the same source. So this states records previously obtained. So if additional pages are produced and they were not previously obtained, this regulation would not defeat the invoice or payment. So there's more reasons here. And when I started in this industry, I was scanning records. That's how I got started. And I believe, and I think that this is true, that to save costs, that defense party subpoenas may exclude date ranges and categories of records from the witness in the first place. And also for the same reasons, when serving records to the applicant attorney, the defense party may intentionally leave out pages that they feel are unnecessary. I think that's all I got on my slide.
Okay, so when are copying services unnecessary? And when we look at this is a binding decision from 2019, Monaco, we just call it the Monaco case, pretty big case in the copy service world. And so right in the Monaco case, the board, they were actually quoting another case, but they said the public policy favoring liberal pre-child discovery. Let's see, my things getting covered up here. Let me bring this down. So the public policy favoring liberal pretrial discovery that may lead to relevant and admissible evidence is applicable in workers' compensation cases, and that's from the Allison case. Thus, the parties have broad discretion in seeking and obtaining documents with a subpoena ducis tecum in workers' compensation cases. So what does this mean, liberal pre-trial discovery? And that's usually quoted from a copy service standpoint, because the board is going to expect that the applicant attorney does have a right to go do discovery. He has a right to his independent discovery so that he can properly represent his client. And that's important because when a copy service goes in front of a judge trying to support their invoice, and it's like, when the defense attorney says, why were your records necessary? You have to prove your services were necessary. And that's how the copy service is going to prove it. They're going to say, hey, look, we have an en banc case that says that the parties have a right to liberal pretrial discovery, and that's really what this is. So I'm running the slideshow, by the way, so that's why I'm struggling around with windows popping up. So when are copy services unnecessary? I think it's a good point here to sort of point out to you guys why an applicant attorney orders records from a copy service. Why doesn't the applicant attorney just take whatever you give him? He's got his medical reports, maybe you served PTP records in the beginning of the case, maybe not. But just to give you an idea for some of the stuff I've heard in the past from applicant attorneys as to why they're using a copy service. Obviously, the first one is they want to identify all available claims. So lots of times the applicant, they just have a back injury, and that's what they're complaining about, and that's what's being treated. But in the process of treating that back injury, they're given drugs and various treatments, and those treatments can also have an effect. And in the process of this going on, the applicant attorney sees, well, heck, the back injury is probably caused by an ankle injury that they also had. So again, you may not like this idea, but from an applicant attorney standpoint, in their shoes, they need all the information they can because their job is to prosecute all the claims they can find for that applicant. And that's just the way the system works. So,
gentlemen, question, if you don't mind, I'm going to jump in real quick. It says,
sure.
Aren't all parties of records related, the subpoenaing of records? My biggest contention with some of the fees is that we get a $75 cancellation invoice, but neither my attorney nor I knew about the subpoena of records.
Yeah, this is it shouldn't happen that way. I would say if that is happening, then something's wrong. A subpoena should be noticed to all parties. And the $75 cancellation fee, this is covered in another question. We do, I know from my perspective, I know Mike's perspective, we do a good faith effort to make sure that records actually exist. And if our client asks us to go somewhere, we don't want to produce a certificate of no record, that cancellation fee. In fact, we find that we consider that a failure. We believe that our clients really want to get records, and or sometimes they want to prove that records actually don't exist at that particular spot.
I would also say that if you get that a lot, first I would notice who the provider is. The second thing I would do is I would ask them for a copy of the subpoena that was sent and a copy of the proof of service of the subpoena that was sent out. Because that should list who was served and the date that it was served, and what documents were included with that. So that, I agree with Dan, that is a practice that should not happen. I can assure you that as an applicant copy service, and we're going to kind of cover this a little bit later, we provide our whole point to being in business is to provide good service. If I am going out and not obtaining records, my client is going to find another copy service that will. So cancellations should not happen. We do everything that we can to not have that happen.
To Mike's point too, all of that information is required on an invoice. So by regulation, I forget the exact one, that information for you to do the research to figure out, that information is on the invoice and required.
Should be provided on that invoice. Yes.
And to speak to the idea that you never even received a copy of the subpoena, the first thing you saw was an invoice for cancellation. Since like 2009, or I don't know when it was, but when the free web case search for EAMS was put up, I'm sure these two guys have staff in their office that when they get an order for services, first thing they do is they go look in EAMS and they see who the parties are on the case and the attorneys, and that's what they use to serve their subpoenas. So if I think it's a good argument for you to definitely challenge such an invoice and say, look, you didn't serve me with the subpoena and you're required to. I'm objecting to paying this service because the deposition wasn't set up properly. We were a party, we were in EAMS, and that information was publicly available and you didn't use it. Now, if they serve their subpoena with a proof of service and says they served you, that's a bigger fight. But
and I do believe that 90% of those, at least from our side, that we just didn't get the right information maybe up front, or the right information was not in EAMS. That happens, and or the mail process within the insurance company just isn't serving you properly.
Gentlemen, I have another question, and then my other question will be, would you like me to save the questions to the end or continue to give it to you as they're coming in?
I say bring the questions. We want to keep this lively and interesting.
Absolutely.
Okay, so,
Diane, I'm also watching the questions, so I can pull those in as we go along.
all right. Well, Brandy is asking, what if you have your copy service send the AA records at the same time that you receive them?
So I think the question there is, you're a claims adjuster, you go use your copy service, let's call it MacroPro, and you instruct MacroPro to send the same copies of records that you get to the applicant attorney. And therefore, if the applicant attorney turns around and immediately requests those same records from that same place, isn't that duplicative? And that very well could be duplicative. What it depends upon is, did the applicant copy service, you can look at the subpoena and see, did they request the same exact records that MacroPro did, or is there a difference there? Because the claims examiner may only be interested in a certain date range of records or certain category of records, and the applicant attorney may want any and all records. And in pretty much every instance here, if you feel it's duplicative, well within your rights to dispute that invoice and bring that matter in front of a judge. And the judge is going to be responsible for looking at the MacroPro records and looking at the Gemini records. And if they are duplicative and the same, I think you're going to win every time on that. And Gemini's not going to get paid. But again, an applicant attorney and a defense attorney, imagine if the DWC passed a regulation tomorrow that said, hey, look, the applicant, it's their records and they're responsible for their own records. So we're not going to let employers and defense attorneys order any records. We're just going to let the applicant attorney drive that. Applicant attorney can go out and get the records and only serve you with the type of records that they feel is appropriate to serve you. You would hate that. You couldn't do your job. You wouldn't be able to do apportionment. You wouldn't be able to, properly investigate your claim. Applicant attorneys feel the same way. Unfortunately, there's not a lot of trust with a lot of applicant attorneys. Not all of them. Some of them will certainly accept what you serve on them. But again, the regulations don't state that an applicant attorney can't go get records from some witness just because you did and you served them with it. Again, from your standpoint, if you feel it's duplicative, challenge it. But the ultimate answer the judge is going to have to get to is he's going to have to look at both sets of records. And if they're not the same, it's not duplicative. That's what it boils down to.
I think it's pretty important that people understand how narrow it is to prove duplicative. And what we're trying to get to here is that threading that needle is pretty difficult. It's probably very difficult to do, number one. Number two, both sides have equal right to the discovery, as Stephen's explaining. And the board did not, and the WCAB, DWC, they did not dictate that one side gets records and the other can't. In fact, there's the Hardesty case says that both sides have the opportunity for liberal discovery. So when you go to object, understand threading that needle is difficult and it costs a lot of money.
And I think that's the point too. Duplicative is a very fine needle to thread. So, and I understand why that bothers you, because obviously nobody wants to duplicate their efforts. I assure you, nobody wants to do that. But threading that needle costs, it drives costs. And remember, we're arguing about a nickel of costs. And $1, the copying services are a nickel of those medical expenses that you want to argue over. And it's this one duplicative, oh, you did ask MacroPro to get these records, and so did the applicant attorney. Is it really worth your time and the attorney's time and all of your efforts to go ahead and try to thread that needle to try to get a duplicative finding in your favor? And I would say this is something I believe, this is what our service would do, Republic. If you say, look, MacroPro copied 105 pages from the same source, and Republic copied 105 pages from the same source, my collections team, and you guys copied it first, MacroPro copied it first, my collections team would be like, Mike, we need to eat this one. I'd say, okay. And that's how we would do it. So instead of involving defense counsel, instead of going in front of a judge, you could call me and you could say, look, here's proof that you guys duplicated your efforts, and we will gladly take away that receivable because it's going to cost us money to try to chase it anyways. So remember, we're arguing over a nickel, just so we're all on the same page here.
That's a great point. And you're actually arguing over less than a penny out of $1. It's 0.6%. And I think this last bullet item down here is one of the keys. You send out MacroPro and you copy PTP records, and subsequent to that, 30, 45 days later, there's some dispute that the applicant attorney is raising in the treatment. And the evidence for that dispute is in updated records at that PTP location. So I'm not saying that this is the end-all answer and that every single time it's updated records, but just be open to the concept that this can happen. Your records may not be exactly what is in that primary treating physician's files right now, and the applicant attorney may be interested in what's in that file right now. Another thing that applicant attorneys use records for is to prepare their client for the deposition of their client. They don't want to be surprised. And I used to hear this a lot from applicant attorneys that were ordering records, and I was curious as to what they were doing with the records that I was providing them. And just keep in mind that applicant attorney, he or she has a responsibility to vigorously, protect his client's interests, just like you do. If you're vigorously protecting your insurance company or your employer's interests. And so whether or not discovery is necessary, as we've been saying, that's really hard to prove. And is it really worth going to that trouble?
And there's another question here up on the chat, and it's in regards to if your request for records overlaps a period of records the carrier already has in their possession, do your companies agree to negotiate the cost to only include the new records? And we get this question often. Our fees are regulated very specifically. So if I go out and I copy 10 pages of records, and your copy service gets 15 or gets 5 pages. So the difference is 5 pages. Our fees are still the same. Asking us to negotiate, the fees are set for us. There really is no room for us to negotiate. Those are our fees. And so to this slide here, just because you feel like, sorry, Stephen, just because you feel like the applicant attorney may lack good cause for ordering records, just because that's the feeling that you have, or that you suspect that he's just running up costs, it's not a legal or even a reasonable ground to try to drive costly dispute within the system and try to get in front of a judge. The key, I think, here is that if the invoice itself is compliant with the regulations, then it really should be paid timely. And and that way you guys risk any unnecessary penalties or sanctions. And remember, as Stephen pointed out, we keep bringing this up because we want to drive the point home. We're talking about, I did my rough math and it was terrible. It's under a penny. It's almost half of a penny of the overall cost of a case is for copying services. And that's what you're arguing over.
Yeah, thank you. So this is an important point, and I think that is a little deep in the weeds, but what is the difference between formal and informal discovery? And this is important. The only form of discovery appearing in the CCP, the Code of Civil Procedure, that is authorized by the Labor Code is the deposition. So this is a little in the weeds. Stephen, maybe you can kind of help us out a little bit. Stephen's our resident scholar.
Yes.
I can read this, but go ahead, Stephen.
The point that we're trying to make here is from a claims person perspective, especially when we're talking about you're getting subpoenaed, your own records are getting subpoenaed by the applicant attorney. Again, we get the frustration there, we get the resentment there. You're like, I can just serve those records. And oftentimes the applicant attorney write in their notice of representation, there'll be a demand for service of all, maybe not all, but for certain documents that's inside your file. What we're trying to point out here is you then get frustrated because you produce something based on that request, and then it gets followed up with a subpoena from an applicant copy service for your records or your employer's records. And you're frustrated by that. And yes, it's kind of in the weeds, but it's important because an inspection demand, which does appear in the CCP as an official form of discovery, is not supported in workers' compensation. In workers' compensation, we've got case law, I think it's Hardesty, and it says, hey, the only time the CCP is to be used in workers' compensation is when the Labor Code authorizes it. And Labor Code 5710 authorizes the deposition. And so what we say is the only form of discovery that's allowed in our system is the deposition, not this notice to produce. So what is it when the applicant attorney makes a written request or demand for your records? It's not a deposition. It can't be an inspection demand or notice to produce, because that's not enforceable in workers' compensation. It is literally just a good faith ask of you, and you're under no legal pressure to comply or to comply thoroughly. And so that's really what we're trying to point out here is, if just because you served some of your employment or claims records on the applicant attorney and you feel like you did your job, think about that from the applicant attorney's standpoint. You could have sanitized that. There's nothing to stop you. You're under no legal obligation to not sanitize it. And so in a sense, even though it's common for applicant attorneys to make this request, it's common for you to comply with this request. And it even appears in Labor Code 5307.9 that authorized the fee schedule. It says that, hey, there's this 30-day delay period where if the applicant attorney asks you to produce records, you get 30 days to do it. And there shouldn't be any copying services done within those 30 days. And all of us on this presentation here agree with that. If the applicant attorney makes a request, they shouldn't get involved. The copy service shouldn't be involved during that 30-day period. But we also want to point out why you end up with a subpoena after there's already been this informal request and you've complied with it.
Yeah, thanks, Stephen. So we're driving this point home a little deeper. Reg 106.3.5 also reinforces this concept of informal discovery versus formal discovery. Records of any type are not required to be produced informally. Applicant attorney routinely include an informal written request for records in their notice of representation, but this is unenforceable and unreliable. Records can be sanitized, and we've all seen actually that be the case. Stephen, go ahead.
Well, the point here is this regulation 106.3.5, you are legally compelled to produce these types of records, but only these types of records. It's a benefits paid and it's the medical reports. And of course, anything that you intend to file. Those are the only records you're legally compelled to produce outside of a deposition. And therefore, you're probably going to end up with some sort of deposition notice, because the applicant attorney or certain applicant attorneys are going to want to be looking for records that you didn't freely give them because you were legally compelled to by 10.635.
Yeah, I think this is pretty common, that a common misconception that defense parties are required to supply everything to opposing counsel, and that's not quite true. Labor Code 5307.9 authorizes the fee schedule for copy services, and as Stephen pointed out, it refers to a written request, and this is very informal the way it's written, but it refers to a written request for records made by the applicant, and then requires that 30-day delay. Records produced to an applicant attorney informally in response to a written request are usually sanitized. Now, we wouldn't, we don't say always sanitized, but they do have it. I, again, started in this industry copying records, and I was sitting next to somebody scanning from the defense a set of records, and they were given specific instructions to include or to exclude particular years and or exclude particular parts of the record. So this actually does happen. Again, as we pointed out early, that the applicant has a different perspective and need when it comes to their records. They may be looking for additional compensable injuries or compensable side effects to medications. So having the entire record is important to the applicant attorney.
That's a great point, Dan. So how can you avoid getting a subpoena for your claims or employment records? The reason I had us sort of go into the weeds on whether that's a notice to produce, what is that informal written request for records? The reason I went through that is if you want to avoid that subsequent subpoena, and I'll just tell you from experience and from listening to these guys, from an applicant copy service standpoint, nobody loves a request to copy claims or employer's records. They are a huge pain, simply for this reason. Defense attorneys and claims examiners don't want to produce everything in their file to the applicant attorney. So applicant copy services do not have no love for doing this. Keep that in mind. And of course, you don't either. So how can it be avoided? Well, I think the best way to avoid a subpoena for your records is when the applicant attorney does make that written request, treat it like a notice to produce. And what does that mean? It means include a declaration under penalty of perjury certifying what you're producing. And you say, oh my God, what a pain. I don't want to do that. Totally get it. But look at it from the applicant attorney's standpoint. If you're going to provide a declaration certifying the records that you're providing, and you do so under penalty of perjury, that's going to give that applicant attorney some level of confidence that you didn't sanitize, that it would be unreasonable for them to turn around and then subpoena those same records when you actually produced them. And there's lots of records that you or your defense attorney are going to tell you should not be produced because it's privileged. There's all sorts of privileged information in the claims file that you don't have to produce even under a subpoena. But rather than just not produce them, if you list it, you list on your declaration when you're serving the applicant attorney informally with the records, here's what I didn't provide you and here's why. Also, since we have a code section, we have Labor Code 5307.9, and we also have it inside the regulations, that you have 30 days to respond to those written requests. So do it within the 30 days, include a declaration, and include a proof of service. If you're asserting a privilege, express it so that the applicant attorney knows about it. Now, it may be the applicant attorney is going to respond to that and is going to want to bring this in front of a judge and he's going to want to try to overcome that privilege. But again, you're just trying to avoid the subpoena. So I'm saying if you want to avoid a subpoena, treat the applicant attorney's informal request as if it was an actual legal form of discovery.
Stephen, we're running up on 7 minutes. I wonder if we can hit some high points and then maybe answer a couple questions.
Well, I was going to explain motion to quash, but maybe we'll just skip over all that.
I see some questions in regards to a motion to quash. I don't know that we want to, but how to dispute an invoice. We got a lot of stuff to cover. Maybe.
So this is a common question though. Do they still owe if what happens when a quash is served upon us? Right, there's two different things that we need to point out, right? The request can be quashed. Now the invoice is a different story. That's an objection to that cost as opposed to a quash to the subpoena. The question is though, what happens? Does the applicant copy service stop working? And I'll tell you from our perspective, we don't stop working until there's a signed order by the judge, because a quash is pretty easy to produce and serve upon us. It's just a warning. It says, hey, we don't like what you did, but that doesn't stop us from continuing to work until we get a signed order from a judge.
I think it's important to point out that when you're doing a petition or motion to quash, you're objecting to the forms, procedures, and timelines used to set that down. You should not be issuing a petition to quash because the records are duplicative, because the applicant attorney didn't make a request, or the copy service didn't wait the 30 days. Those are all objections to the services or the invoice. But if you go through and you read the code sections, and they're in the slides, you'll get it in the PDF, and you look at what's going on here, you really should only be objecting if they use the forms or procedures or timelines wrong. And you can win on that. And a big requirement that people leave out is you're required by law in the CCP to do an informal request to resolve this before you do the petition to quash. In other words, you're required to contact that applicant attorney and try to work this out before you file this petition. And I don't see that, almost never is that done. It's just knee-jerk reaction. Defense attorney gets involved, immediately serves this petition to quash. And typically that petition to quash won't have anything to do with the forms, procedures, and deadlines. So the copy service is like, I don't know what to do with this. You're upset because you think it's duplicative. You're trying to stop me, but this isn't the proper form to use to do that. Object to my invoices. I mean, really, why should you care whether they get the records or don't get the records? What you care about is you don't want to have to pay for it. So don't.
And I think
Don't pay for it.
It's a slippery slope too. We're not that what you just stated. Those regulations aren't being enforced on a regular, and the question is, will they be enforced? And that opens you up. That opens you up if you did not meet and confer prior to filing a motion to quash. Are you opening yourself up to sanctions? Is it even worth it? Is it even worth it to do that?
Well, and I think it's worth kind of driving home that the motions to quash that we see, it tends to be, this is unnecessary, this is duplicative, it isn't likely to lead to discoverable evidence. And, all of those really should wait until the invoice comes. If you're going to file that motion after meeting with the applicant attorney trying to resolve it, if you're going to go ahead and file your motion to quash, that it should be on the procedures, on the forms being used, and timelines. That's what you want to focus those on. Go ahead. Sorry. Yeah.
I know we're running out of time, so I'm going to just try to blow through this stuff. About disputing an invoice.
Stephen, I'm
Yes.
going to say, if you have materials that you really want to cover, those people who have been on the webinar for an hour and decide they don't want to continue will receive their certificates because they were on for that amount of time. So if you want to run a little late, for those people who do want to hear the rest of what you have to say, we can do that.
Okay. Fair enough. We'll still try to move along quickly here. I wanted to point out how to dispute an invoice because a lot of times people bring these EORs, explanation of review, or objections to me coming out of bill review companies, and really it's frustrating because the objections that they make are usually related to the e-billing codes, which have nothing to do with copy services. There's really no copy service e-billing codes in that regulation. So you end up with objections like treatment not authorized, almost all treatment type.
OFMS object, right?
Yeah.
Yes.
So if you're going to object to a copy service invoice, please read Regulation 9984. It is a detailed overview of how to dispute an invoice. It's a medical legal expense regulation, and that's what copy services are. So 9984 explains exactly how to do it. Use an explanation of review, use a proof of service. Otherwise, there's a dispute as to whether you did it timely or not. And you use a reasonable dispute code. There's that e-billing dispute code. And if you're not raising a dispute on one of the copy service regulations, particularly that 9982, I don't know that it's going to be a reasonable objection because, again, that Labor Code 4621, the reasonableness and necessity of the services, well, the DWC's gone to great lengths to give you their version of what's reasonable, and it's in those code sections 9980 through 9984. So that's where we should be getting those objections.
I want to speak to those that are still on just for this last minute, and I really think Mike said this. If you have questions or concerns, reach out to us first. I hope that you would feel more comfortable with your services over time, that we're following the law, and quickly move our requests and invoices to allow your workflow so you can work on things that are more important. And I would take this a step further. If you're in leadership, you may be being told to push this to dispute. You may be told to object, and I would have you challenge that with your upper leadership, and even consider putting some copy services that you trust on a whitelist. And this would really, really help, I think, everybody. The cost of dispute is pretty unnecessary. And think about this, okay? Who's benefiting from that cost dispute, okay? Dispute where it makes sense. That's kind of what I wanted to say to people that are last.
You know, and to drive that home, we as a coalition are working to make sure that our services and our member companies and this industry are as transparent as possible. We want to talk to you. If you see Republic on an invoice, you're like, man, this looks like this is nonsense, please call us. We have our phones are open. I've got an entire staff to deal with you guys and to talk to you. And we are reasonable people. And so we would appreciate that. And I agree with the whitelist. I think if you see copy services that are not a part of our coalition, you know, I'm not going to tell you what to do with that, but you know, it's there's a reason that they're not a part of the coalition. So we appreciate you guys very much today. Thank you for your time.
Gentlemen, thank you very much. I see that there's a request to get your contact information. So I want to remind everybody that you can download the presentation today. The screen here that is on front is in the handouts. Are your phone numbers in there, gentlemen?
No, but I'm easy to find. LinkedIn, yeah, I'm easy. I think we're all easy to find.
Okay. So you want to reach out to them, that would be really great. Well, we want to thank you very much for all the information, for the preparation, and for answering people's questions. I'm sorry we weren't able to get to every question, but this is a hot topic, as you can see. Until next time, we do have more 12 CEUs of Christmas. The next one will be on Friday. So be sure to go to the Macro Pro website if you'd like to sign up for more classes. And until the next time, I'd like to say thank you very much. Bye-bye, everybody, and happy holidays.
Thank you.
Bye.
Thank you, everybody.
Thank you, everyone. Appreciate your time.
Have a happy holidays, everybody.
Merry Christmas.
Bye-bye.